Hello, good afternoon, everyone, and welcome to our conference call at immigration.com. This is Rajiv S. Khanna for immigration.com, the law offices of Rajiv S. Khanna PC. Before I get started, Monica had asked me to make a request that please subscribe to our YouTube video channel. That way you can get all our videos in one place. And if you have any questions or concerns, um, you have all of them answered in the proper subcategories within the channel. So please subscribe. And as usual, I will get started and answer all the questions that have been posted first. I have said this before, and when you log in, you hear this recording that this is merely an information call. It does not create an attorney-client relationship. My first question today is about H-1B visa stamping in general and in third countries like Canada. I want to address this issue as a frequently asked question. It is a problem. Um, the biggest issue that has come up these days for the last couple of years in visa stamping is that there is absolutely no predictability. Okay, let me get started by saying that certain countries are much more difficult and they create a lot many more problems than certain other countries. India is one of the problem countries. If you go to India, China is also like that, Pakistan is like that. Um, European countries tend to be easier going. Canada is a little bit easier. So depends upon where you're going. But in general, if you can avoid going for visa stamping, do so. Because if you do go for visa stamping, there's no predictability how long it will take. It could be 3 days, or it could be 3 months, or 6 months even. Okay. Consulate is free to ask you any questions. They ask sometimes questions about, and this is true in H-1B context, L-1 context, J-1 context, any of the visa stamping contexts, they can ask you questions that go far beyond your application. These are questions that can go into um, um, such things as, in H-1B context, I have seen them come back and say from the employer, obtain a copy of their tax returns, obtain a copy of all the names of all the H-1B people working there and where they are employed, and copies of the contracts of the sites where they're working, which is a ridiculous request. Some of these requests, of course, as a matter of principle, our office would refuse to comply with. Okay. But in general, visa stamping is difficult. Avoid it. It can take a lot of time. The question raised by Aya is, can I go to a third country? I'm from Russia. Can I go to Canada? So she went from F1 OPT to H1. Can I do first time stamping in Canada? And the answer is yes. There is no law that I know of which says you cannot do your first time stamping outside your own home country. This is called TCN processing, third country national processing. For H-1B, it is fairly common. And uniformly, consulates have been accepting it, except when their workload becomes too heavy. As a matter of practice, it is a good idea to send an email to the consulate before you go in, and they do respond. It has been my experience that consulates have become more and more responsive to email requests. So before you go in, go ahead and send an email to the consulate and say, look, I want to come for visa stamping. This is my first time stamping. I'm from Russia. Can I come for stamping? Would you entertain my application? And I don't know any reason why they shouldn't. First time stamping for people can be hard or difficult if their degree cannot be verified. For example, if you have a degree from a country other than USA and you go for stamping to Canada and the US consulate in Canada says, look, we cannot verify your degree, so you have to go back to your home country. That's always possible. Okay. You can definitely go to a third country, and I don't know of any reason why they would have suspended. I have no information that Canada has suspended doing third country national processing. Double check with them. Okay. Canada, Mexico, people go to Jamaica, Bahamas, all these different places. But you can go to any country really. The country that is obliged to take your application for H-1B is the country of your permanent residence, such as if you have a permanent residence to Canada, they have to take your application, or the country of your citizenship. That said, I want to make a couple of things clear. Certain cases are easier for stamping than others. When you are working at a client site, not at your employer site, it becomes a lot more difficult to get visa stamping. There's no general rule about this. I won't say that this happens in every case, but we are seeing it become more and more difficult to get stamping when you have a client side placement. Um, if you are working for on a technology that could be potentially classified as weapons grade or some kind of weaponizing technology, even something as innocuous looking as perhaps study of some amount of drug delivery through viruses. I've seen that happen. Consulate can hold you, and this is true for university researchers. It has happened to people I know. It's very difficult to get out of that security check. But usually, you should have some kind of indication in the petition itself. This is what we do, that very clearly says that this is not a weapons grade technology and this is what you do. And hopefully, the consulate looks at that and does not put you through extensive checks. But in general, you can go to a third country, even if it is first time H-1B stamping, as long as they can verify your degree. So if you have an American degree, certainly it becomes a lot easier. Okay, um, you can you should be prepared to spend an extended amount of time because you never know what they are going to call you up on. Okay, so in general, I avoid H-1B visa stamping if I can, but if I cannot, then I keep these things in mind before I send you out. Okay. Anybody has any questions on visa stamping that I have discussed, please press *5. Any aspect of what I've discussed, press *5 on your phone. No new questions, nothing else but what I have discussed. Okay. There is one question from Vermont. Vermont, you can go ahead, please.
Hello, Rajiv. Thank you for your help. This was my question about H-1B first-time stamping. So I know that Canada has suspended doing first-time H-1B stamping starting this past June. Do you have any information regarding that? Do you know if it is still suspended or they released it?
I have no idea. Personally, I do not know. I have no official notification that says that they have suspended for a long period of time. I know that there was a suspension for a couple of weeks when they were doing some, whether it was workload redistribution or something was going on. But I don't think this is an ongoing policy. Please double check with them. Also remember, there is more than one consulate in Canada, not just Toronto, but there are other consulates also. So double check if all consulates are doing it. You can also go to Mexico, you can go to, like I said, Bahamas, Jamaica, all these other countries as well. But before you go, make sure you send them an email and make sure that they are okay about taking your application.
Thank you.
You're welcome. Good luck.
Thanks.
Okay. Let's move on to the next question. So for SG22, I-94 expiration date with passport expiry date question. So his wife got the I-94 expiration date of March 2015 because her passport was expiring in March. H-4 visa in the passport was expiring in December. So they were applied for a renewal. The question is, what is the easiest and the cheapest way to get an extension? And that, of course, is Form I-539. That is probably the cheapest and the easiest. As long as you file as long as USCIS receives your extension application, remember you can do it online. When you do it online, delivery is immediate. As long as they receive your application for H4 extension before the expiration of current I-94, which is March 2015, you are okay. Even if the case is pending and March 2015 has come and gone, as long as the application is filed in a timely manner, that is the way to do it. Okay, so I personally prefer the I-539 route because you can also get an extension beyond December 2015 as long as the H1 is good beyond December 2015. So if your H1 is good till 2017, you file I-539 for your wife, and apply for extension of H1 all the way up to 2017. Okay, I think that's the way to do it. EAD for H1, H4 rule question. I can't comment about this because we really don't know what the final rule is going to look like. Okay, right now we have very little information on what the government is going to do with the final rule. We have a proposed rule, we have comments, but we don't know what is going to happen in the final analysis. So let us just not bring these questions up until we know better where the government is going with it. Okay. Next question again is a frequently asked question. And as I said earlier, for frequently asked questions, I will invite a follow-up right away. So applying for EB1 and average processing time. So Sridhar has PhD in science from Delaware, H1B quota of 3 years, spouse has her own H1B, but she's gap exempt, 6 years end in October 2015. Job is ending soon, I don't have a job, but I need to stay. I need to either get a green card or go on H4. So if I move to H4, can I go back to H1B when I get a job? The answer is yes, of course. Okay, that is no problem at all. And you don't have to go through the April-October life cycle. Because if you have an H1 approved within the last 6 years and it was a quota H1, you can easily go back to it even after you've been on H4. Okay. While on H4, can I file an EB1A green card? The answer is yes. You can file a green card under any employment-based category based upon, in many cases, offer of employment. In some cases, like EB1A and national interest waiver, you don't even need an offer of employment. Okay. What does that mean? You don't actually have to have a job, you just have to have an offer of a job. For EB1A and for national interest waiver, you don't even need an offer of a job. Okay. So can you do it while you're on H4? Yes, absolutely. Not only can you do it while you're on H4, you can do it if you're outside USA. We've done cases where a scientist or a physician or a businessman was sitting outside in India or Pakistan, some cases from Europe, and we filed their EB1A application, EB1C applications directly and got them here on a green card. What is the average time? Well, some EB1s can be processed under premium processing. And remember, it's the I-140 that gets premium, not the I-485. The quickest approval, start to end, that I have gotten in the last 5 years was 3 months. We had a green card approval in 3 months for an outstanding researcher. Average time, I would say, under a year for the whole process if you file your I-140 and 485 together. Okay, now I'm inviting questions on this topic that I just discussed. Anybody has any question? Press *5 on your phone. *5. Any question on? Yes, I got one question. *5. Okay, let's go with the question that we have. Illinois, go ahead, please.
Hello.
Yes, Illinois, I can hear you.
This is in regards to question number 12.
No, you're too early. I'm just asking about the topic I discussed. Okay?
Okay, sir.
No problem. Okay, so then let me move on to the next question. This is another one I have marked as a frequently asked question. It is very common for countries where dates of birth are not really the only means of identification. India is a very typical example, Pakistan, Bangladesh. A lot of these countries, we don't have these identifications tied to the date of birth. So often you'll find that when parents took you to get you admitted, something went wrong, and in the school certificates you have some other date of birth, passport some other date of birth, in the birth certificate some other date of birth. Now here is my answer to that situation. First of all, you don't have to leave USA and go away. Okay, this is what Raj was saying. Should I just forget about a green card? No, not at all. Okay, what you do is when you file your I-140 485, make sure you mention your correct date of birth. Try to get your documents corrected. If you cannot get them corrected, you have your lawyers file affidavits explaining in detail what happened. But always go with the correct date of birth. Have we done this in the past? Yes, we have. Have we had problems? A little bit. We have to make sure the government understands what the reason is and that we are not just being cute and trying to take advantage of the system in some way by creating a false identification. As long as the government is convinced about that, I usually have seen no further problems. Okay, so don't just give up. There should be a detailed explanation. You should make attempt to make sure that you have corrected all the information about your date of birth on your passport, on your school certificates, whatever you can correct. Correct it. Whatever you cannot correct, document it. I tried calling this person, talk to them on this date. This is what they said. You can't correct this, or whatever the reasons are. Okay. So yes, you do need your correct date of birth, and because the documents for immigration in the United States are all filed under penalty of perjury, your information must be correct. Okay. Anybody has any question about discrepancies in date of birth information? Press *5. Any question about discrepancies in date of birth information? Press *5. Okay. No question about that. Another frequently asked question. This is from RG513, change of employers applying H-1B visa. So here is, just in general, I have a comment here. The conventional wisdom is, if you are in the United States and you came into USA with a proper H-1B visa, you worked for that employer who sponsored you. 6 months later, you changed employer by doing a H-1 transfer. Can you use the visa stamp of the old employer to travel in and out of USA? Conventional wisdom was yes, and we have always advised people, yes, you can. Yesterday, when we checked with the consulate, just to be sure, I had done a consultation for somebody, and I was curious because consulates are frequently changing their minds. Consulate came back and said, oh yeah, if you change employers, we still want you to come and apply for a new visa when you travel outside. To me, that's ridiculous. So we are taking this issue up with the visa office in Washington, D.C. We are going to ask them if this indeed is a central policy, or is this... See, consulates can want what they want. Unless it is a central policy or an accepted policy, I really don't care what they want. They can want the moon. We are here to obey the laws, not the whims and fancies of bureaucrats who make changes to policy without notification to the public. So it's a general rule. When you change employers within the US, you should not have to change visa stamping. Okay. But this is still up in the air. Always a good idea to double check. To come to RJ513's question, I have a valid I-94 till 2015 April with my previous employer. Then I got converted to full-time with the same client. Now I have another. So he got hired, or she got hired from the client, from the employer to the client. Should I go for stamping? And that is exactly the situation I just described. We are checking with the National Visa Office. You can check with the consulate independently. They are telling me we want you to come in for visa stamping. That is not my understanding. I have never done that. Now you have to take your pick. Contact your lawyer, see what they have to say about it. Contact the consulate. Have your lawyers contact the National Visa Office. See if they can get you, if you can get some answers to a unified policy. I have seen nothing from the government on this issue. There is no document that I know of, no memorandum, no change in policy that I know of. Okay. So I can't give you a good answer other than to say check what their thinking is today. Every few days they seem to change their mind. Okay. Anybody has any questions about change of employers and applying for H-1B visa? Press *5. One question. Okay. Ma'am, go ahead. I can hear you. California, go ahead.
Okay, this is Gautami. I was the one who posted the question.
Go ahead, please.
So, Rajiv, I already have my dates, my stamping dates reserved in India. So that was my question, whether I have to go or not. Because I may not go visit my country again before March 31st, before my existing stamping expires. So that's why I thought in this visit I could go and get my new stamping done.
Well, in general, I'm against having to go for visa stamping. Every time you go, you don't know how long you're going to get stuck. Okay. Uh, Fortunately, you have gone from working from a vendor to a client, and usually that makes it a little easier to get a visa stamping. But to answer your question, if you had asked me this question day before yesterday, I would have said you have no need to get a new visa. From their answer from yesterday, I don't know what to tell you because we are going to take up this issue. In fact, we have sent an email to the National Visa Office. It usually takes them 2 weeks to get back to us. Okay, so if you want to check back with me after 2 weeks about whether we got a response from the visa office, feel free to do so. My email is easy. It's help@immigration.com. Go ahead and send me an email.
Okay, and one last question I have is there a time frame that we need to wait to go for stamping? Like in my scenario, for example, I have my stamping till March, right? Do I have to wait for a certain period, like 3 months or 6 months? Few of my friends told me that I can't go for another stamping if my existing stamping is valid within the 6 months
That answer would
or
have
90 days.
that answer would have been true if you were applying for an extension working with the same employer. You've changed employers, so that if the consulate does want me to get a new visa, then they can't have any kind of limitation. Okay?
Okay,
All right.
thank you.
Good luck.
Yeah, thanks.
Okay. Next question is from Dexter, Pradeep. J2 dependent, a Canadian citizen. They've got a 2-year home residency requirement. His spouse is a physician. So the problem is, I have an EAD on J2. Once the J1 training is over, I lose my EAD. Can I change to any other work visa? And you are correct that there is a memo from USCIS that says you cannot get work authorization until, or you can't get an H1 until your spouse completes her 3-year waiver. However, TN you can get. You can't get H1. Okay, but TN is not subject to home residency requirement. If you look at 212E, it's an interesting problem. If you look at 212E, it says you can't get H1, L1, or green card. It doesn't say you can't get O1. It doesn't say you can't get E1. It does not say you can't get TN. So all these visas are available. You can definitely go for TN. I don't see any problem with that. Okay, but again, this is the way I read 212E. You can double check with USCIS. I personally think there is no doubt in my mind that's the way it should be. Next question is DVNIGS. Completed my 6 years on H1 in August. Applied for labor certification in November of last year. So there's a gap between August and November. Well, first of all, you know that you can apply for your H1 extension 6 months ahead of the date you're going to become eligible in your case. So November is when you become eligible. May is when you can apply. So in May of 2014, which is a few months back, you could have applied for an extension. Of course, the extension will begin from November 15th or 16th of 2014. Okay. I'm sorry. It will begin from August of 2015 because you started your, no, I'm confused. Scratch everything. You started your green card on November 15, 2013. That means in November 2014, 10 days or 7-8 days from now, you become eligible for extension. So you can apply for an H1 extension. And I can apply for I-140. How can this be done? Well, I think I'm a little confused about how much information you have and how much you don't. So let me just look at your case and tell you what you can and cannot do. You can file for an H1 now because in November 2014, which is this month, November 15th, your labor cert would have been pending 1 year. Whether it is approved in audit or whether it is in appeal before BALCA, doesn't matter. You are entitled to 1 year extension. If the labor cert and when the labor cert does get approved, the perm does get approved, and you get the I-140 approved, then you'll be able to get 3-year extensions in the future. And that's the way the law works. So you will get H1 extension beginning November 15th or 16th of this year. File for your H1 right away. No problem at all. Next question is from Alpana, which is a difficult question to answer because Alpana had her H1 visa issuance date was December 2006, expiring in 2009. So that means, and this is something I actually did check with USCIS. They told me that we want you to have an approval of H1 within the last 6 months. And approval is considered to be all the way up to 2009. So because 2009 falls within the last 6 years, even though your approval was in 2006, they take the entire 3-year period and they take the last few days or whatever to make you eligible as being within the last 6 years. So since 2009 you would be is when your H1 expired, you should be eligible to be cap exempt until 2015, 6 years from 2009. If we counted from 2006 when the H1 was approved, you would not be eligible because 2012 is come and gone. This is my understanding. Have they changed their mind again? I don't know. But this is what they told us last month. We had inquired, we had a similar situation like that with a client. We have that H1 pending. So in my view, the 6 years should begin from the expiration, not from the approval. That would make you eligible in 2014 to get your H1. In fact, right now, since you don't have to wait for the quota, you're not subject to the quota. But if you have spent 6 years already on L1B or any other visa, you have to be outside USA for 1 year. Just keep that in mind. Okay. Petros wants to know, 15 years of education, 10 years of experience, filed my green card in EB3, want to change it to EB2, doing my master's 2 years from India through Open University. With my master's, I'll be eligible for EB2. Yeah, if your master's is recognized, if it is accredited and recognized in USA, better get that double checked. Okay, don't take it for granted. I will complete in June 2015. Can I file my EB2 in Jan 2015? No. You can prepare the application, start placing ads and all those, but on the date you file your perm, you should have your degree in hand. You should be fully qualified for the perm. Okay. Another question from NCAS, I have marked as a frequently asked question. And the question, this comes up quite often. I have a green card pending. For example, my brother applied or my parents applied for me and I'm outside USA. Can I get a non-immigrant visa? So technically, if my green card is pending, I have exhibited my immigrant intention. I'm going to stay in USA forever. Will they give me a non-immigrant visa? And the answer is it depends. Some visas are dual intent visas. Okay. Expressly, they allow you to have a green card pending. H visa, H1, H4, all these visas are dual intent visa, not H2. H2 is not dual intent, but H1 is dual intent. Okay. O1 is dual intent. Okay. E3 is dual intent. E1, E2, I believe, are dual intent. Some visas are not dual intent. For example, B as in tourist visa, F as in student visa, J visa. These are not dual intent. If you have a green card pending, USCIS or actually the consulate can give you trouble about that. So if you want to apply for a student visa once the I-130 has been filed, it may be difficult. It is not impossible, but it may be difficult. Usually, consulates will not issue a student visa. When it's a dual intent visa, you have no problem. H1 people go and get their green cards, their visa stamping all the time while the green card is going on. Absolutely fine. By law, it is okay. These are dual intent visas. Okay. Anybody has a question on this issue, on dual intent visa issue, press *5 on your phone. *5. Okay, let me go on to the other questions. And of course, we'll start taking the new questions once I'm done with this round. Another frequently asked question. I was denied entry, withdrawal of application for admission under INA, Immigration Nationality Act, Section 212A7A11 and 235B1. Okay. First of all, withdrawal of application for admission is not a bad thing necessarily. It basically, when you come to the airport, if CBP wants to be nice to you and you have a problem, they'll say, okay, we'll let you withdraw your application and go home. Because if they exclude you, then you can't come back, I think, for 5 years. If they formally tell you you can't deny admission, you can't come back. But if they allow you to withdraw your admission, you can come back the next day, provided you overcome the problem. This 212A7A11 is the section that deals with immigration intention. So if you, for example, if your fiance or your wife is living in USA and you try to come in on a student visa or a tourist visa, CBP can say, no, 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 your wife or your husband is living in USA, you have to go back. Okay, so you don't have any ban and you don't need any waiver. You are applying for your marriage through marriage to eventually a U.S. citizen. So the fact is, the prior withdrawal of the application for admission does not create any problems for you. I personally don't think it will be a problem. You have asked me, is there any waiver that I need? I've already answered that, no. Is there any bar? The answer is no. What time frame does NVC take to notify the consulate, and can it be Hyderabad, India? That's, you can take that up with NVC. And NVC's time frames are widely different, Samir. I don't know exactly what their time frames are, but I'm making a guess here. Within 2 to 4 months, I think they take care of everything if your paperwork is complete. Your green card process after the I-130 approval and the upgrade to the spouse of a U.S. citizen should be between 6 and 10 months at the most. Okay, that's my guess. These times can vary, they can change from time to time, as well as application to application. Okay, so you have a question on this? I see that. Anybody else has any question on this? All right. Let me take Kentucky. Go ahead. Kentucky, I can hear you. Kentucky? Kentucky.
Hello?
Yes, I can hear you. Go ahead, please.
Do religious organizations like churches and social service organizations fall under non-profit organizations? And can we apply H1 with non-profit quota?
Okay, ma'am, you have asked me a question that is completely irrelevant. Right now, I'm inviting only questions based upon what I just discussed. Hold on. Guys, please pay attention. I am only asking or inviting questions on the issue that I'm talking about. At the end of this round of questions, I will invite new questions. Okay. So going back to my posted questions, this question has been posted by Monica, our Chief Technology Officer. She must have received it from a community member. It says that one of her friends, or one of his friends, had to travel back to India after her husband died in an accident. He was a green card holder, 2 kids who are US citizens. She stayed in India. She didn't realize that she has to return, she has to live in USA. When she went to the consulate to obtain a re-entry document, she had to surrender her green card. Okay. So she's come back on a tourist visa, and she has to travel out of the country every 6 months because the kids are studying here, I gather. Okay, well, first of all, she should be able to get her B1 extensions within the United States. In a situation like this, I believe that she can ask for unlimited extensions as long as the kids are going to school. In my experience, even though it's not written down anywhere, USCIS does accommodate cases like this, and they keep giving extensions. Can she get her green card back? That is a very difficult question to answer. I think it's been too long. I think it will be too difficult. We can try looking at this case, but it is likely to be a very, very long shot. I won't say it is impossible, because nothing is impossible, but it is going to be a very, very long shot. Okay. What would be our fees? Um, I do not know. I do not know. I would have to know a lot more about her case history, um, and see if there is any real argument. But the problem is, once you have surrendered your green card, getting it back is an extremely long shot. I don't even know if I can do it. Okay, so think it through. Let us know if you want us to help you. I don't think I can help you. Crazy bin, I have completed my MS from US, currently on H1B visa. My company recently started my green card perm process. Oh, by the way, guys, there are two questions on um, political asylum. I'm very sorry, I will not be able to answer them. Two things I know nothing about: DV lottery and political asylums. We have never practiced in these areas of the law. So please, I'm sorry, I will not be able to answer. If you are waiting for me to answer a question on political asylum or DV, please hang up. I will not be able to help. I wish I could. Okay, so going back to this question by Crazy Bin, completed my MS from the US, currently on H1B visa. Company started my green card process through perm. I've got the questions. I came to USA on a student visa in August 2006. So what has happened is, in his background experience, um, by mistake he showed only one company's experience, but he actually had two companies. So does it create any issues if I show my accurate work experience this time in green card perm process? First of all, you have no choice. Perm is a form that is filed under penalty of perjury. You have to give the correct information. Okay. And personally, I think it is not that big a deal. It doesn't look like that big a deal. Have your lawyers assess it. If you are our client, I would definitely have you tell the truth. If there is a fallout, we'll deal with it, but it's got to be done. Okay. Next question: reissuance of Indian passport to a statusless immigrant. So the problem is this: I have no clue what Indian passport laws are. So really, I cannot do anything about it. This is related to asylum, and then you withdrew the application. Now, how do you get the Indian passport? I have no idea. This is about Indian laws. Okay, sorry. Next question is from Pravan. Currently working for company A on H1, and I need to get my visa stamped if I go to India. Few questions on three topics: H1, H4 EAD, and I-140 portability. So H1, H4 EAD, and I-140 portability. I got an offer from company B, and they'll start my H1 transfer process next week. I'm going to India in December and continue to work for A after I return, and then join company B somewhere in January. And during my stamping, I may or may not have the approval from company B. Will it be a problem? Well, first of all, if you are going to come back and continue working with company A, I think it's okay for you to get a visa stamping through company A, even if the transfer for company B is approved. As long as the transfer application was filed within the United States, when you were within the United States, you should be okay to travel and come back and join. Okay. So, but if you are outside USA and then they file your transfer application, you cannot join employer B without coming back and applying for transfer again. Okay. Next question: once the H4 EAD rule is in place and my spouse gets EAD, if I change employer, previous employer, you're asking me questions that I cannot answer, because what the new regulations will say, if there are any new regulations, I do not know. Priority date can be carried forward when we change employer, and even when the old employer withdraws the I-140. Does it have to? Yeah, that's a good question. Very good question. So the question is, if I change jobs, I know that I can keep my priority date even if the old employer revokes my I-140. Correct. In order for me to carry the priority date forward, does it have to be a same or similar job? The answer is no. When you carry a priority date only forward, the jobs can be completely different. No problem there. Next question is from Venkat1237. Also, I have marked as a frequently asked question. My wife came to, so this is filing amendment for a pending H1B petition. Let me explain to you what the problem is. Let's say I apply for an H1B for myself, and I'm going to work for IBM as the end client. When we filed the case, suddenly 3 months into the case, my client changed, and now I'm going to go work for Sun Microsystems. Can I file an amendment in midstream? And the answer is it's very problematic. Normally, USCIS, they used to be okay with it, and they did that until about a year ago. Last year or so, USCIS has been saying, if your situation changes while the case is pending, we will not accept that change. You have to file H1 again, and if you're out of status, you have to go outside USA for visa step. Okay. So in your case, wife came to US on H4, applied for H1B, got an RFE. For more project details, she got one job offer meanwhile, and her employer replied for RFE and also filed separate petition with the new job offer details. See, in her case, there's a little bit of a better situation in that because she's on H4, she's still maintaining status. They've applied for an amendment separately, it might work. But if she's a quota case, that becomes another problem, because if the first case is not approved, then of course the amendment cannot be approved. So keep that in mind. Any questions on what I've just discussed? Filing amendment for a pending H1B petition. Press *5. Any question on this issue? No new questions, just on this issue that I discussed. Okay, let's go on to the next one. So for Priya, well, she calls herself Priya and also signs as Amy. Okay, so Amy says her OPT was denied because they say she did not go for biometrics. She never received the notice. So she filed a motion to reopen. It's been pending for so many months. I've paid so much money. What can I do to move this case along? Well, contact your congressman's office. Just that is the best thing to do, because this is horrendous. They do it. Sometimes people fall into this. Just go ahead and contact your congressman's office. That's the best thing you can do. Okay, they might be able to move this thing along. Next question is another frequently asked question, and I want to address this because it comes up quite frequently. And that's why it's a frequently asked question. So if you have a criminal conviction, a lot of times you can have criminal convictions for minor problems. For example, you got into a altercation with somebody, you were all out drinking, or some kind of public nuisance conviction. In this case, they were selling alcohol to a minor, didn't check the ID. So the question is, how does that impact my immigration status? Okay. Well, first of all, there are two categories of crimes: misdemeanors and felonies. Felonies, and I could be wrong with the definitions by just a little bit, a smidgen. Felonies are anything which are punishable. Don't have to receive that punishment, but punishable by more than a year in prison. They are more serious crimes. And misdemeanors. Misdemeanors are anything less than a year. A year or less, I think. That's a misdemeanor. Less than a year or less is misdemeanor. Okay. So we look at whether the crime is a misdemeanor or it is a felony. Then we look at whether there is moral turpitude or not. Moral turpitude is a term of art. Pretty much anything that involves deceit, dishonesty, that is moral turpitude, or reckless disregard of other people's safety or attack on people. These are typically, they call them misdemeanor, they call them offenses of moral turpitude. Okay, so if there's moral turpitude and there's a felony, chances are you've got a problem. Okay, but if there's only one misdemeanor, even if it is a turpitudinous crime, it is exempted by something called petty offense exception. Petty offense exception says if you have only one misdemeanor and the sentence actually imposed upon you was, I think, 6 months or less than 6 months, one of the two. Less than 6 months sentence imposed. Whether you actually served it or not, even if it is suspended sentence, it is considered to be sentence. Then we don't bother. We'll leave you alone. We'll give you your green card. We'll give you your H1. We'll give you your F1. So petty offense exception. So once again, we look at the crime. Is it a crime of moral turpitude or not? If it is not, chances are you're going to be okay. If it is a felony of moral turpitude, you have a problem. If it is only one crime, misdemeanor, you don't have a problem. This is a very generic overview, because sometimes we had a case a few years ago where I think in Arizona, if I remember correctly, and I'm very careful with these cases because I know how complex these situations are. Somebody called us from Arizona and said, "Oh, I just had a misdemeanor. There's not going to be a problem, but can you double check and just make sure?" Of course, it takes a lot of work because we have to look at the statute. We probably want to get an Arizona lawyer involved, make sure we understand exactly what the statute says and we've got it right. So there is something called aggravated misdemeanors. So that's like a felony. So don't be too sure you know what is going on. Normally, when I look into these cases, first thing I do is I try to see if we can get away from a conviction. So if we can get the case settled with the government, a plea bargain entered without a conviction. What is a conviction under immigration law? A conviction under immigration law is where you admit having committed the offense. Okay. If you have to admit the offense, then it's a conviction, no matter what kind of deal you make. Okay. So we try to get away first of all from conviction. If we can do that, then we are safe because there is no conviction, there's no crime. If we can't do that, we bargain for a misdemeanor or a non-moral turpitude offense. So that's typically the way we handle these cases. So he wants to know, I have only one misdemeanor. Is this going to be a problem? And the answer is probably not. But have your lawyers look into it. Make sure it is a misdemeanor under the state law. Okay. You say it's a misdemeanor C. I don't know what that means. The state law has to be checked. But it looks to me you should be okay. I hope that answers your question. Anybody has any question about crimes, misdemeanor convictions, petty offenses, etc.? Press *5. Any question on this topic? Okay, let's go on to the next question. This is from Kiran, who says, I was on L1B from 2007 to 2012. L1A from October 2012 to March 2014. I stayed more than 6 years. I had one H1B with a different company, good from 2012 to 2013. Never joined that company, never used it. Visited India for 3 weeks in April 2014, came back on H4 visa. Can I use my old expired H1B? No, because you have already used 7 years of your L1. Unless you stay outside USA for more than 1 year or 1 year, you cannot get any of the time back. If you stay outside, or if some company files for my green card and completes my I-140 in USA, can I get an extension of my H1B? Well, you can definitely, well, that's an interesting question. When you've done your 7 years on L1 and you come back, I'm not sure I know the answer. I'll have to figure this out. Let me see if I can. You come back, so you've got your time period over. Can you apply, for example, under the quota because you've got your I-140 approval? I think you can. I think you can. So you can always apply under quota if the I-140 is approved or PERM has been pending 1 year. Okay. Are you exempt from the quota? Your H1 was in 2012. It looks like you should be exempt from the quota. So without leaving USA, you might be able to. This is a very quick analysis. As far as I can tell, I think you can. And I would like your lawyers to spend a whole lot more time than I have, which is about 2 minutes, in deciding this. But it looks to me, if an employer files your green card, you can get back onto H1 and not be subject to the quota. Especially if your H1 was approved with a change of status. If it was not approved with a change of status, you will not be able to. Okay, let's see. We have a question from Preet G. I'm sorry, I can't answer that. Don't do asylum cases, don't know anything about asylum. Pavitra Gupta says, company applied for my H1B extension. They accidentally mentioned me as part-time, whereas I'm full-time. You have to do an amendment. Okay? You have to do an amendment. Next question, Suri 18873. Suri 8873. My wife worked on H1B from May 2006 till March 2011. She went to India in March for visa stamping. Visa was rejected under misrepresentation. Oh, wow. Incorrect client letter. She came to USA on H4 visa. Well, if there was a misrepresentation finding against your wife, that is a permanent bar from entering USA. So I'm not sure how she entered USA. If it is a letter submitted by the employer and she was not the one committing the misrepresentation, she's okay. So look into that issue, because a visa fraud or misrepresentation is a permanent bar from entering USA. So is she eligible to file H-1B under cap exemption? As her previous H-1 period was still remaining, it 2011. I think so. I don't see any reason why not. If everything else is okay, it looks like she can get an H-1B without a quota issue. Okay, guys, I'm done with all my posted questions. Let's first of all ask people. Anyone who posted a question has a follow-up question. Press *5. No new questions, only follow-up questions. *5 for any follow-up questions. 1, 2, and these are all 3 follow-up questions on what has been posted. No new questions. After I'm done with this, then we'll start with the new questions. Okay, let's start in the order that you logged in. 4 questions. New Jersey, go ahead please. New Jersey, you just raised your hand a second ago.
Yeah.
Go ahead please.
So, Rajiv, can you post my question?
Can I post your question?
Hello?
What do you mean, can I post your question?
No, I'm saying that can I post or ask my question?
Is it a new question or a follow-up on what has been posted?
It's a new question.
I have to ask you to hold. Okay, no new questions, guys, just the follow-ups first. Okay, Delaware, go ahead please, Delaware.
Hi Rajiv. Yeah, this is I'm reference to this question number 14.
14. 1 second.
So
let me hang on. Let me get to it. Let me get to it. Give me a moment.
Sorry. Yeah. Go.
1 moment. Let's see what's going on. The reissuance of Indian passport, is that what you're asking me? No.
No, crazy.
One before that. So I've got my MS from US, currently on H-1B.
Correct.
Or you showed only one company's experience, and I told you, you have no choice, you have to tell the truth about your experience.
Okay, and does it create any issue? Means like, because innocently on that time I was not that sure, and I have mentioned, okay, this is my work experience.
And you do that on DS 156?
Yeah, it's I think 8 years back I have filled up that form when I was on
see, in my opinion, that should not make a difference, because it really is, even if it is a misrepresentation, it is not intentional and it is not material. How does it matter for the grant of a student visa? You came on student visa. So how does it matter whether you worked at one job or 2 jobs? I don't think it's a problem.
Oh, so yeah, I have to mention everything correct this time, right?
Yeah, you have to mention everything correctly this time.
Sure.
All right.
Not a problem. Thanks for your help.
You're welcome. Good luck.
Thanks.
Okay. Jersey City, go ahead, please. Jersey City. Jersey City. Area code 201, Jersey City. Go ahead, please.
Hello. Hi, Rajiv. This is Samir from Jersey City. Sorry, I was on mute.
Oh, no problem. Samir, what number question were you? Yeah, I see you.
I think it was from the top 2, 3.
Yeah, I see you. You are quite. Is it about the withdrawal of application for admission?
No, that
You put yourself down as SG22?
Yeah.
Okay, I see your question. So this is a situation where wife got an I-94 for till March 2015,
Mm-hmm.
and you wanted to know how to extend it.
Mm-hmm.
And I said filing Form I-539 is the best way to go.
All right, yeah. So I joined, by the time I joined, I think you were answering this question, so I heard it. So you said it's good to file 539.
Yes.
But Rajiv, if we do go, because Mexico is not too far away from us, because I'm in California. So can we just, I mean, is it, one of my friends already had this done for his kid, because his kid was also on H4 because he came from India. And they just got it done, like they went and within a couple of hours they crossed the border and then came back. And is
Well,
there any
hang on, hang
visa
on,
needed for Mexico?
hang on, hang on, hang on, hang on. Let's back you up a little bit. Tell me, when does your H1 expire?
Sir, mine is December 2015. It's expiring.
Okay. Are you going to apply for any amendment, anything soon, or are you good till December 2015?
I should be good. I'm not intending to file any
Okay.
amendment or anything.
In that case, since she's not entitled to extension beyond December 2015, you can go outside and come back in. Okay. As far as I know,
Sure.
and I'm not a Mexican lawyer, as far as I know, Mexico does not require you to get a visa if you are traveling by road. Okay. And as far as I know, again, getting an I-94 extension through that method should be relatively easy. Okay. So if you can travel and go in and come out, yeah, it should be easy enough in my view.
Yeah, so basically those folks would know, this is not a new thing for them, because I heard many people just go and my only worry was that, don't want to get stuck the way sometimes people get stuck in India for when they go for stamping and stuff.
Why don't you go to CBP first and ask them if they can extend it within USA?
Sir, I did talk to them on the phone,
Right.
and they happen to be aware of this thing. And what they said was, because we did not do anything wrong in sense, because they
Yeah.
normally,
Yeah.
the impression I got is that if it was our mistake, we would correct it.
Right.
It's not
Right.
their mistake because the passport thing. So they sort of were asking me to actually, go outside the country and do this or file online. So they were giving me other options, sort of not agreeing to what I was requesting them to do, like, if I can come there and get it done. They
Sure.
were not really,
Sure.
very encouraging in that.
Sure. I think visit to Mexico should be okay. We've had clients do this in the past. We've also had them go to CBP. And I think you are right, because a couple of weeks ago, I had a client with a similar issue. And when he went to the CBP office, they told him that we cannot do this anymore, because unless we have made an error, like if you had
Yeah.
if you had a visa and a approval notice, and we gave you extension till only your visa, only then we'll correct it. Personally, I think they are wrong, because they should have given her till December 2015, even though her visa expiration date, her passport expiration date was March 2015. I think you should ask them anyway. You should go to the CBP
Yeah, I
officer.
think I'll ask them again. Yeah.
No, don't
Yeah,
don't
I just said,
don't talk to them over the phone. Go to the CBP office and ask to speak with a supervisor. See what they say. It doesn't hurt to ask.
yeah, it doesn't have to ask, and I was probably planning to just go there. And sometimes it's much different when you meet in person than on the phone. So
Yeah.
I think they can maybe they might entertain the request.
No harm in asking.
All right, sir. And yeah, sure, sir. So follow-up other thing which I had was a very important thing. It's for EAD. I know there's nothing going on that, and nobody knows anything. But I have I was doubting one thing, because I was getting some offer from some other company, where a full-time
There
offer
is
maybe.
Samirji.
And
There
if
is
I
no
if I
point. No point in discussing this, because I won't be able to give you any answer. So what is the point in discussing?
okay,
We don't
the
know.
point was that I know this.
I don't know what the
I know,
law.
sir, that.
I don't know what the law is
Okay.
gonna be. I have no
All
idea.
right.
Okay. So sorry.
No, all right, sir. Then thank you. Yes.
You're welcome. Okay, guys. Any questions? New, old, follow-ups? Press *5. Any questions whatsoever? Please press *5. Any questions? New, old, very old, *5. So far I have three questions, or three people asking me questions. Okay, let us get started in the order you folks logged in. I will answer these three people, and then we'll be done for the day. Okay, and we'll be back on schedule in 2 weeks again. We'll talk again every other Thursday. Uh, New Jersey, go ahead, please. New Jersey.
Yeah, my name is Malay Mohanty. Actually, I posted in this forum one question yesterday because I thought what my green card was with an gender error. And when I checked with the USCIS, I think I-9 the form has to be filled and send it back. My only thinking is that how can I know whether it's an administrative error or it's an error from my employer side? Because I didn't get anything from the employer side about the filing the form or the details.
Well, the green card is based upon the I-485. The I-485 is your application. Have your lawyers give you a copy of your I-485. Review it. If the mistake was made by the lawyers, you have to file I-90. If the mistake was made by USCIS, they should correct it.
Okay. In that case, like since I got this green card, so my visa status will be void, right? So I will be only considered as a permanent resident here.
You are now a
My
permanent resident.
green card has to
You are now a permanent resident, and this minor error in the green card does not affect your status.
Okay, so I should not be worried about my visa extension or staying here, all these things, right?
You are
So with this permanent resident, I can, yeah.
You are absolutely fine. Just don't travel outside USA until you get this corrected.
Okay.
And if you do need to travel while this is pending, you can get your passport stamped for travel.
Okay, so if by chance if I need to urgently go, you never know, right?
You can go to get an InfoPass appointment, go to the local office, ask them to stamp your passport for travel.
Okay.
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 Good luck. You're welcome. You're welcome.
Thank you.
Okay, one more person had joined those three people, so no problem. We'll do all these cases. Let's go to the next person from Ohio. Ohio, go ahead, please.
Yeah, hi Rajiv. Is this a follow-up question or are you taking up new questions right now?
It doesn't matter. Any questions?
Okay, my case was that I was on an H4 earlier in 2013 and I got my H1 this year. So as the validity starts from October 1st, my current employer is looking for projects. So I'm not right now on payroll. So just wanted to know, like, can we stay, like, is there any time period wherein we can stay on H1 without a payroll?
Well, that's a tough question to answer. I can tell you what the law is. I can also tell you what the employer is doing is illegal. Okay. The law is if an employee is in the United States, the employer must place them on the payroll and start paying them on the earlier of the following two dates. One, when the employee is willing, available, and ready to work. So if you call the office and say, I'm ready to come today, they have to start paying you right away. Okay?
Okay.
And the second is 60. Hang on. Let me finish. The second is 60 days. So there is a 60-day quote unquote grace period under the Department of Labor regulations. But that does not mean they don't have to start paying you if you're ready to start working now. In fact, Department of Labor maintains that if they start marketing your resume or if they start talking to people or they start training you, they have already taken control of you. No excuses, they have to pay you. Okay, go ahead.
Okay, so can it be like for the time period I'm not getting any project, can I ask my company that I can go on a volunteer leave or something and maybe they can get a document signed? Will that work or no?
It is still illegal, and if you become a party to any kind of voluntary leave, etc., you could be committing fraud. So unless it is true, don't do it. Okay?
Okay. Okay. And the second question would be like, if I want the H1 to be transferred to some other company, do we require any pay stub? Like pay stub, is that an essential part of the document?
Yes. The
Because my okay.
yes. The transfer requires you show that you are in status, and status
Okay.
is
And
status is shown by pay stubs. If you are in that 60-day grace period, you can argue that they could not find me a project, etc. But I don't know if USCIS is going to consider you to be in status in those circumstances.
okay, because my H4 is like till December. I have it till like December 31st.
Stop,
I have
stop, stop,
994
stop,
for the
stop, stop,
H4.
stop, stop, stop. You got a change of status to H1, right?
Yeah, I got it, but I think
Stop,
they did not
stop,
file a
stop,
COS, so I'm
stop,
not
stop.
sure.
Ma'am, you have to let me have my input, because until I finish my sentence, you will not be able to understand.
Okay, I'm sorry.
Yeah, just calm down. We have time. No problem. We can take our time about this. I only have three more questions, so no problem. Let's just do it slowly so you understand. Once a change of status is approved, on October 1st, you are no longer on H4. You are on H1. Okay?
Okay.
Makes sense? So forget that you are on H4. You are not on H4. If there is a change of status, you are on H1. It does not matter if you have the I-94 of the H4. Change of status overrules your H4. Okay?
Okay, got it. So you mean that if H1 is applied right now, I am on an H1. I do not need to apply a change of status separately for that.
You are already changed into H1. I'm assuming that they applied for change of status. If you got an I-94 with your approval, you are on H1, and you are in violation of status if you're not getting paid.
Okay, I got it. All right, thank you so much.
You're welcome. Good luck.
Thank you.
Okay, we still have two more people. All right. Florida. Go ahead, Florida.
Hi, Rajiv. This is Sagar here. Good afternoon.
Good afternoon, sir.
In the beginning, thanks indeed for hosting this call, Rajiv. That's very helpful.
My pleasure.
My mother, Rajiv, my mother is 80 years old, and she went back to India last year on a green card. And we were thinking that she would come back before the end of the year, but due to health reasons, she has not been able to come back. So, and we have not applied for re-entry permit for her. So, my question is, because because of her age and because of the health reasons, do you think she will be allowed to come back? She has a green card earlier next year when she might have completed about 17 months in India. Do you see a risk, or what should we do if there is a risk?
Is any of her children a U.S. citizen?
Yes.
Okay.
Myself.
Because you can always apply. Even if the green card is gone, you can apply again. That is no problem. Okay. However, if you have health reasons that can be shown by documentary evidence, letters from doctors, hospital bills, hospital entries, she can, as soon as she's able to travel, she must go to the US consulate in India and apply for something called returning resident permit. Returning resident permit, also known as S as in Sam, B as in boy, SB1 visa. Okay. SB1 visa is for those green card holders who, because of no fault of their own, could not come back within a year's time.
Okay.
So if for some reason the consulate does not give her the returning resident permit, then you can always apply for a new green card. Apply for a new green card.
Okay.
All right?
Sure.
Good
So
luck.
and that's an only option. Returning resident permit is an only option for her to come back.
That is the only legal option. Yes, sir.
Okay.
All right?
One quick follow-up question on that.
Sure.
While that is a legal option, considering her age and only happening the delay due to health reasons, do you think on a you can say maybe humanitarian or just as a consideration basis, we should take a chance for her to just travel with a green card which is valid and explain that at the customs? Do you think that's worth taking the risk?
Well, I wouldn't do it if it were my mother. But the law is if somebody is able to land at the airport with a green card, they have to let them enter, even if they take away the green card and ask them later to report to an immigration judge for a deportation hearing. But once they land at the airport, they have to be let in. Okay. Now here's the tricky part.
Okay.
Usually, the airlines will not issue a ticket to somebody who's been outside USA for more than a year.
Okay. Got it.
Okay. Good luck.
Yeah. Sure. Thanks.
You're welcome.
Thanks a lot.
You're welcome, sir.
Thanks a lot.
And this is the last question of the day. I don't know who you are. Your ID is blocked. So go ahead, please.
Hi, my question is, my employer has filed for my I-140, and my fiancée who is in India, the marriage will happen Jan sometime, and once she will need to travel with me to US, and she is someone who was born in Nepal, so I was born in India. So based on certain rules, I probably will be able to file a I-485 after the marriage. My question is, once the I-485 is filed, how long she must stay in the USA, because she wants to travel back to India soon after the I-140 485 is filed?
She should wait until she gets her advance parole approved, and that can take about 3-4 months. After that, she's okay to travel.
Oh, that the advance parole can take 3 to 4 months.
Yep.
Okay. And at what stage after the I-485 is filed and she gets advance parole and goes back to India, at what stage she must be in the USA in any of the follow-up stages of the green card process for me, and she'll also be a part of that. She should be back in the
See,
US.
the way it works is once she gets her advance parole, it's good for 2 years usually. So even if she's outside USA when the green card is approved, that's okay. She can come back using her advance parole. At the airport, they will note that she is a green card holder.
Okay, so pretty much my rest of the green card process can go up to the approval stage while she's still in India.
Yeah, but once the green card is approved, some people send the green card to their wives or husbands in this situation to India and let them travel on it. Or some people just bring them in on an advance parole. What I would like her to do is to come back as soon as she can once the green card is approved. Okay.
Okay, all right. Okay, a follow-up question is, after my I-140 gets approved and I change my employer for any reason or my job gets terminated, um, and the next employer does not agree to file or restart a green card process, can I continue to get my H-1B extended based on the first employer's approved I-140?
Only as long as the other employer has not revoked your I-140. If the I-140 is not revoked, you can keep getting extensions through any employer indefinitely.
Through any employer indefinitely.
Yep.
So I can go to employer number 2, number 3, and as long as employer number 1 did not revoke the I-140 that was approved, I can keep getting H-1 extension.
Now you know the law as well as I do in this area. And the answer is
that is almost like a virtual indefinite H-1 extensions possibility. I mean, I'm just confirming my understanding.
That's exactly what it is, and that's exactly what Congress intended it to be. All right.
Very well, very well. Yeah, that's helpful. Okay, I think that was all.
I have one more
One
question.
last.
I have to, I'm sorry, I've spent enough time
One
with you.
last.
I'm,
Can
look,
I ask you?
you have to be very quick about it because I have one more person waiting.
Is it, after the I-485 is filed, how long does it take to get EAD? And if my spouse intends to work, can she continue to work on EAD while I continue to work on H-1B?
The answer to first question about 90 days, second question, yes. Okay?
Okay, great.
Good.
Thanks a lot.
You're welcome. Good luck.
Thank you.
Oh, somebody had their hand up and they put it down. Illinois, did you have a question for me? Illinois?
Yes, I have a question for you.
Yeah, go ahead.
Hello.
Yes, go ahead, please.
This is a follow-up question with regards to question number 12.
Number 12. One second. Let me get to 12. I don't want to give you the wrong answer. Give me 1 second. Number 12. Oh, yes, yes. Oh, yes, of course. I remember your case. Application withdrawn based upon immigrant intention. Now married to a PR holder, a green card holder, soon becoming a US citizen. Yeah, go ahead. What is your question, sir?
The change of category from F2A to IR1, it can be done individually, right, without the help of any attorney assistance?
Um, 99.9, hang on. 99% cases, if there is no problem in the background, yes. But since you've had an issue at the border, I would be a lot more comfortable if not hiring a lawyer, at least you take a consultation from somebody who goes over your paperwork and makes sure that whatever happened at the border has been properly taken care of in your filing for the green card and it's not going to become a problem. I don't think it is, but I would be doing you a disservice if I said it should just be ignored. Somebody should look at it.
Okay.
All right?
Do we at any point of time, like the documents, the IMA citation that mentioned 212 7AI and that 235 withdrawal of application, can they be sent with the other documents through NVC? Are they supposed to be sent?
Not unless the papers ask for it. I'm pretty sure the papers don't ask for it. So the answer is no.
Can you be little out? Sorry.
I'm pretty sure the papers don't ask for it. So whatever the forms ask for, that's what you have to submit, not anything beyond that.
Okay.
All right?
Okay. So I have like one more question for you. Like, is a direct consular filing a better option than upgrading the petition? Direct consular filing, because I believe it takes 6 months and New Delhi comes in it.
I am not. What do you mean? Are you talking about when somebody is living in India and then they file for their spouse in India?
Yeah, right now my spouse is in US. She can come back to India. Which way is faster?
Yeah, but she has to live in India for a while before she becomes eligible for that. I don't know what their details currently are. I'm sorry, I can't answer that question because I don't know the details. I don't know exactly what the local consular policy is. When I last checked, it used to be you have to be in India for a certain number of days. It was 3 or 6 months. Only then you can file for direct consular processing. And I'm not sure it saves you too much time, personally.
Okay.
Okay.
Okay. One last question for you, sir. After this IR1 category interview, after this interview, after the NVC notifies the consulate, will there be like several checks like name check, background check, and security clearance, so on and so forth?
Yes, there will be. Yes, there will be.
Okay.
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 Good luck to you, sir.
Okay, sir. Thank you, sir.
You're welcome. You're welcome. You're welcome. Okay, guys. The very best of luck to all of you. Thank you for being here. Always a pleasure to talk with you and give my 2 cents worth. And I'll see you again in 2 weeks. I couldn't do a call in between for one session, but we'll be back again. Thank you all. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.